Consumer protection laws. Massachusetts General Law, Chapter 93A, also known as the Private Protection Act, MGL Chapter 93A, was originally enacted in 1967 and amended in 1969 to allow for private right of action. The law is designed to protect consumers from unfair and deceptive practices employed by some businesses. It empowers consumers who feel they have been unfairly deceived by a business with the ability to easily bring a claim against a business and receive compensation for any monetary loss they suffered. Under 93A, all a consumer has to do is bring a claim All a consumer has to do to bring a claim is send a business a letter and provide the business with 30 days to respond. Note that real estate licensees are treated as businesses under 93A. 93A creates the discourse requirements that agents must follow when selling a property, and also creates a liability when misleading or otherwise harming buyers and sellers. For example, if an agent knowingly violated the law or was informed about a violation and did not correct a problem. Under 93A, real estate agents and other businesses are required to disclose everything they know that materially impacts the quality of a property offered for sale or rent. Note that there is no intent standard. The material fact of unfair or deceptive practices is enough to trigger MGL 93A protections, even if those practices were accidental. Also note that unlike agents, private sellers in Massachusetts are not obligated to disclose material defects except for those defects relating to lead paint and septic systems. Title V. The minimum amount a consumer can be awarded under 93A is double damages, and the maximum is triple damages, plus attorney fees and court costs. There is a crucial exception to these damages under 93A. However, if the business makes a reasonable settlement offer that the prospective plaintiff rejects, then the court may limit the plaintiff recovery to the amount of the settlement offer. The following guidelines must be met in order for a case to fall under Chapter 93A of the MGL. The matter must involve a business, including licensees, private party sales. Those that do not involve a business are not covered by 93A. A consumer must have suffered actual monetary damages, wasted money, or be able to prove that unfair business practice may cause a loss of money or property, which can be difficult to prove. The complaining party must write a 30-day demand letter, send it to the business, and give the business 30 days to respond. The time window is not optional. Without the 30 days, it is not a 93A claim. Some examples of practices that might fall under Chapter 93A: a consumer is not fully informed of the nature of the product or is misled. A business does not uphold its refund or return policy. A business does not meet its warranty agreement. A business engaged in false advertising. Watch out, future real estate agents. Home inspection regulations. Buyers in Massachusetts must be given Massachusetts home inspection brochure when they sign a purchase agreement, but they are not required to get a home inspection. An agent representing the seller may not recommend a specific home inspector, since it is a potential conflict of interest. They are prohibited from sharing literature on home inspection companies or even sharing their personal experience with an inspector. Buyer's agents are allowed to recommend a specific inspector. Buyer's agents can recommend one or many inspectors. There is no set number that they must refer. It's always best to encourage consumers to ask their friends and families for recommendations as well. Many home inspection contingencies have a time limit. For example, 7 days to obtain an inspection. So it's important that clients are informed of any time limit and ensure that any inspections are completed before the time limit elapses. Hazardous materials. Environmental hazards are a serious concern. This is especially true for commercial and industrial properties because business activities often involve toxic materials. Any known hazards, for example, fuel tanks, asbestos, chlordane, mold, or radon, need to be disclosed as defects, but do not prohibit the sale of the real estate. A 21E certificate is used in Massachusetts to certify that a real property is free of contamination. A 21E certificate most often is used for commercial properties, but may also be used for residential real estate. Hazards may also be tested for if the seller agrees to the testing. Brownfields are lands that have previously been used for commercial purposes and are contaminated by hazardous waste or pollution, in contrast to green fields, which are uncontaminated lands. The Massachusetts Department of Environmental Protection provides for liability relief and financial incentives under the Brownfields Act of 1998 to encourage the cleanup and redevelopment of brownfields. There are a number of environmental hazards to be aware of. Lead paint. Lead paint is a common hazard since it was used in many homes before it was banned in 1978 under the Residential Lead Paint Hazard Reduction Act. If someone ingests lead by eating or inhaling it, it can cause damage to the brain and other vital organs like kidneys, nerves, and blood. Lead exposure is closely linked to behavioral issues like ADHD, learning disabilities, and lower IQ scores. Because lead paint is prevalent in homes built before 1978, it's important to be aware of the rules surrounding lead paint. They work differently for sales and rentals. Sales lead paint law. Prospective purchasers of residential property built to 1978 must be notified of their lead paint rights prior to signing the PNS with both the Federal Protect Your Family from Lead in Your Home pamphlet created by the EPA, HUD, and Consumer Product Safety Commission, and the Massachusetts Property Transfer Lead Paint Notification Form. It is your responsibility as a real estate agent to ensure that the buyer receives these forms and acknowledges the disclosure of potential lead paint. The buyer is granted 10-day lead paint inspection provision by federal law. They may waive the inspection, but if a child under 6 lives in the home or someone becomes pregnant, the property owner must de-lead within 90 days. There are no exceptions or parental waivers allowed under any circumstances. Rental lead paint law. Federally, there are no laws that require landlords to de-lead. However, the presence of any lead-based paint must be disclosed, and the tenants may withdraw from the lease if they do not find the lead conditions to be satisfactory. In Massachusetts, all properties constructed prior to 1978 and occupied by children less than 6 years old must be tested for lead and de-leaded if the lead paint is present. Landlords cannot deny rental to tenants on the basis of lead paint, even if the landlord has an exemption under the Fair Housing Law, and parents cannot waive de-leading under any circumstances. The only time a child under 6 can occupy a property with lead paint is for short-term vacation rentals, 100 days federally, or 31 days in Massachusetts. Landlords must bear all costs of deletting, including any moving costs to the tenant incurs, and any alternative housing in excess of the tenant's monthly rent. All new tenants, whether they have children or not, must be given mandatory Massachusetts tenant-led law notification forms before signing a lease for a property built before 1978. Other hazards. Asbestos. Asbestos was primarily used, and still sometimes is, as an insulation material and fire retardant. Prolonged exposure to asbestos causes asbestosis, mesothelioma, and lung cancer. The EPA banned asbestos in 1989, but the courts overturned the ban in 1991. Therefore, it is legal to manufacture asbestos in many industries in the U.S., although its use has declined dramatically. It's used in homes and flocked ceilings or popcorn ceilings. Its uses in homes and flocked ceilings or popcorn ceilings was banned in 1978 though installers were permitted to use their existing stocks up until 1986. In Massachusetts, there is no law specifically banning the use of asbestos or requiring its removal from real estate. That having been said, if asbestos is in poor repair or is present in a friable state, the state mandates that it must be removed. Real estate agents should disclose the presence of asbestos per MGL 93A. Asbestos removal and property demolition is subject to 310 CMR 7, which strictly controls removal so as to avoid air pollution and the release of asbestos fibers. The requirement for removal includes using specially licensed contractors, notifying the DEP and the DSL 10 days prior to the removal or demolition, using special containers, double bagging the removed asbestos to prevent its release, and other precautions. Since removal is so expensive, encapsulation, where a hazardous material is covered and sealed off, is often used as an alternative to removal. Radon is a colorless, odorless gas that is radioactive and causes cancer. It is a result of the natural breakdown of radioactive elements in certain soil. Homes can be designed in a way to minimize radon contamination, and homes should be tested if they are located in high-risk areas, though it's always good practice to test, since 1 in 15 homes are impacted by radon. The EPA suggests taking action when level 4 PCI is present in the home. Mold. Mold must be disclosed, but does not prohibit the sale of real estate. In sales, watch out for vinyl wallpaper and exterior installation finishing systems, which are prone to mold. Homeowner insurance policies often do not cover mold, which can be an issue in real estate sales. Stachybotrys is a genus of mold that contains around 50 different species. Of particular concern, S. chartarum and S. chlororhinata are commonly known as black mold or toxic black mold. Black mold is linked to health issues and poor indoor air quality. In rentals, mold disclosure form must be provided with every lease, which details the health harms caused by mold and the conditions that contribute to mold, moisture, poor ventilation, etc. Landlord failure to mitigate mold in a reasonable period of time may constitute a violation in state sanitary code and be grounds for construction eviction. Urea formaldehyde. Urea formaldehyde, or UFFI, is an insulation material. Under some circumstances, it can break down, resulting in formaldehyde vapor being released into a home. It was banned in 1979. Under Massachusetts law passed in 2002, UFFI does not need to be affirmatively disclosed, but lenders remain liable. The disclosure requirements were removed because the material was banned so long ago, and testing has shown that the aged material is not toxic. Chlordane, used to treat pest infestation in the 1940s through 1980s, acts as a chemical barrier to insects entering the home and persists for 30 plus years. It is toxic and can impact well water and air quality and must be disclosed. Polychlorinated biphenyls, PCBs, more than 200 different chemical compounds that are not found naturally. Banned in 1979, PCBs were used as flame resistant in electrical equipment and are carcinogenic, mostly a concern for commercial and industrial properties. Chlorofluorocarbons are non-toxic, non-flammable chemicals used as refrigerants in air conditioners, refrigerators, and freezers, as well as aerosol sprays, paints, and other products. They are safe in lower atmosphere, but can cause ozone layer depletion, and have mostly fallen out of favor since 1996, in the exception of limited applications, for example, asthma inhalers. Underground storage tanks. Typically, USTs, or underground storage tanks, are storage tanks for chemicals or gas that are more than 10% buried in the ground. In Massachusetts, they are banned under 21E and represent a hazard. Disposal requires the presence of a fire department in the DEP. Personal removal and disposal at the dump is prohibited. Title V requires septic systems to pass an inspection within 2 years of a sale, 3 years if they are pumped every year. If weather conditions prevent an inspection before a sale, the inspection can be done for up to 6 months afterwards, providing that the seller notifies the buyer in writing of the need to complete the inspection. Seller and buyer decide who brings the system into compliance if it fails inspection. Only Mass DEP approved individuals who have passed a certification course can conduct system inspections. A list of inspectors is available from the New England Interstate Water Pollution Control Commission. In an effort to reduce nitrogen pollution, Title V requires residents living near nitrogen-impaired watersheds to upgrade their septic systems to include enhanced nitrogen-reducing treatment technology under the town applies for a watershed permit. A watershed permit allows communities in the Cape to create a range of innovative water solutions for water waste, tailored for the specific needs of the last 20 years. Drinking water. The Safe Drinking Water Act of 1974 permits the EPA to set standards for drinking water. Drinking water issues must be disclosed, and buyers should usually test wells and non-municipal water systems for contamination. Massachusetts smoke detector regulations. The sale of real estate built prior to 1975 requires a smoke detector certificate signed by a local fire chief. Most real estate sales will receive an inspection, even if it's not legally required because of lender or buyer requirements. Smoke detector rules are based on the year the property was built and the type or number of units in the property. Requirements regarding placement are based on the size and number of floors in the dwelling. In addition to national code, every town has their own specific laws regarding smoke detectors. Single or two-family properties built prior to 1975 may have battery-operated smoke detectors. Single or two-family properties built or permitted after 1975 must have interconnected hardwired detectors. Those built or permitted after 1997 must have interconnected hardwired detectors with battery backup. For 3+ unit properties, the rules are based on international building codes. Fire inspectors typically follow each town code regarding these properties. Smoke detectors must be placed on every habitable floor, in the basement, on the ceiling, at the base of the stairs, within 10 feet of each bedroom or sleeping area, and if the attic is finished, there must be one on the ceiling. Photoelectric detectors are required within 20 feet of kitchens or bathrooms. There are usually a requirement that detectors are required for every 1,200 square feet of living space. If the property was built after August 1997, an additional requirement is that the smoke detector inside of each bedroom. There must be a smoke detector inside of each bedroom. After September 2008, heat alarms must be placed outside any attached garages. Typically for common areas, 2+ unit dwellings, alarms are required in the lobby, any common areas, and stairwells. Whether they are battery-operated, hardwired, or alarm type 1 or 2 systems depend on the total number of units in the property. Note that Massachusetts, as of December 2016, 10+ old battery-operated detectors must be replaced with photoelectric sealed 10-year detectors. Any smoke alarms that were installed prior to this date and met the requirements at that time are permitted until the detector reaches a year age of 10 or exceeds the manufacturer's life date of the device. Combination smoke and carbon monoxide detectors are permitted but must have a tone and voice feature. Massachusetts carbon monoxide detector regulations. Effective March 31st, 2006, all homes in Massachusetts that are equipped with fuel burning equipment that produces carbon monoxide adjacent to living areas are required to have carbon monoxide detectors installed on every level. The law applies to all homes, not just the ones that are being sold. New home construction or renovations must have hardwired detectors. Older homes may be brought into compliance with battery-operated detectors. Construction warranties. People frequently assume that there is a guarantee of 1-year warranty for all new construction. This is not the case. Generally, construction warranties state that builder or contractor must use materials that are new and good. Their work must be free of defects and executed according to the agreed-upon contract. These sorts of warranties are quite general and do not include a specific time frame. Only a court can determine the validity of any claim arising from improper construction practices under such a warranty. Builders or contractors sometimes offer a more robust construction warranty for a short period of time after the purchase. These warranties cover any construction defects in the newly built property. There is no legal requirement time frame for these warranties, and the warranty will be based on the particular agreement. In Massachusetts, there is an automatic 3-year implied warranty of habitability for any purchasers of newly constructed property. Neither the buyer nor the seller can waive this warranty. The warranty covers the structural integrity of the property and the systems and the mechanics that keep the property habitable and free from the elements. A judge determines if there has been a breach of this warranty on a case-by-case basis. Okay, and that's consumer protection laws.